Ladies and gentlemen, welcome aboard the Pilot Lawyer Podcast. Thank you for your attention while this important legal information is reviewed. What you hear should not replace consultation with an attorney and should not be considered advice for your situation. On behalf of the Pilot Lawyer and your entire crew, it's our pleasure to have you aboard.
Welcome, aviators, to the Pilot Lawyer Podcast with us, the Eisen Brothers at the Eisen Law Firm. We're here to help pilots and those who want to become pilots navigate the FAA medical certification process. Around the office, we frequently say, if you don't laugh, you cry. And so for the next 30 minutes or so, we hope to bring you the lighter side of what can otherwise be a frustrating process.
I'll note that we've changed
the intro. The intro is not done. I mean, come on, man. I had one more.
You took a long pause. He was posting up to say something.
Getting ready to say something, so you didn't say something dumb, and now here we are.
Yeah.
We've wasted a perfectly good intro. I don't care. I think we use it. The intro stands.
Fine.
Forget it.
Fine. All right. We can cross the first thing off our outline, banter. Moving on to the second thing. So what we're here to talk about today is the specifically disqualifying condition of substance dependence. What is it? How is it? Where is it?
When you say specifically disqualifying, is that a term of art within the regulation?
It's a beautiful term. It was a beautiful call, to quote 45. So here's the thing. You're correct. Under the Code of Federal Regulations, Part 67, that's where the FAA has identified the criteria for which an individual needs to be in satisfaction of in order to hold a medical certificate. Therein, there are only certain conditions which are identified in the regulation as being one which an airman cannot hold a medical certificate if they have it. For example,
history of epilepsy,
having a pacemaker, type 1 diabetes. Give me another one.
Coronary artery disease.
Yeah, that's required treatment. Okay. 2 on the list, the very short list, are substance abuse and substance dependence. Now, what does this mean? What specifically disqualifying? Essentially, procedurally, it means if you have it, the FAA can just deny your medical application right off the bat.
Hear this? That's the rubber stamp coming down.
From Oklahoma City. They can just
denied.
They can stamp it and say denied. Whereas if you have ADHD, for example, or PTSD, these are conditions that are not specifically, if you pulled open the book and you were thumbing
through the book of regulations,
and said, I'm not seeing PTSD in here. That's because that's not a specifically disqualifying condition. And it falls
referenced by name.
Yes. It's one of the catch-all conditions that you'll find at like 67.107C, which essentially says if you have a condition that at the federal air surgeon's discretion is going to prevent the airman from being able to safely operate as an airman, then that airman is denied. So the way that works out differently in Oklahoma City is that you can get denied in Oklahoma City for that condition, but it's subject to reconsideration by the federal air surgeon, such that the federal air surgeon has to look at it and say, yeah, this condition is going to keep this airman from safely operating. So really don't need all that, but I gave it to you because I'm a giver. I'm not a taker.
I don't know. It looks like you're a taker when it comes to the buffet.
The whole buffet.
I give way. Well, you give way and I take the food.
He gives wake.
So substance dependence, which is what we're here. I've called you in special, Christopher, to have this podcast.
I know.
To talk about because it is a specifically disqualifying condition. And if the folks in Oklahoma City think you have it, the lower level review, you're going to get denied a final denial, which you can appeal to the NTSB. All of that's neither here nor there at the moment. But just know that when you are applying for a medical certificate, you have to go about this with an eye toward identifying whether, yes, I do have substance dependence and I'm in recovery, or no, I don't have substance dependence. Because if you give the FAA information saying that you meet criteria for substance dependence, they're going to deny you right off the bat for it.
Well, one of the interesting things I think between...
You think something
I do think something's interesting. You tell me if I'm right, if I think this should be interesting.
Okay.
But if you look at some of the other regulations with specifically disqualifying conditions, like maybe bipolar disorder, right? Or psychosis, things that generally you're going to be able to kind of go back through the medical records and say, yeah, that person had it, like coronary artery disease that's required treatment, or epilepsy, right? I mean, these are medical conditions that you're going to pretty much have a pretty good medical record establishing that event occurred, right? Sure. And then you're going to tell the FAA about it, and they're going to deny you. Whereas with substance dependence and substance abuse, even though it is specifically disqualifying under the regulations, there is a bit of a nuance in how the FAA defines substance abuse and substance dependence compared to maybe what a clinician would define some of these other conditions that are specifically disqualifying.
You know, we got a very small table here, and at the table we have our own physician, Alex.
Oh Lord.
So if somebody were to walk into a physician's office and say, "Hey, do I have a problem with alcohol?" How are they going to assess that?
Well, they ask a detailed history.
You're on the wrong track here.
Okay.
That's not what
Are you talking about the DSM?
Yeah.
Well, then why don't you just come at me and say what criteria
we're trying to give you? We're trying to give you some reason to exist here on the podcast.
Listen.
Okay?
My reason to exist is to give you nonsense answers like this, and you got to cue me up better because that was.
I don't know.
Crap.
It's literally right here on this little scrap of paper.
We wrote an outline.
The next thing to talk about is the difference between the DSM-5.
Well, don't you have to take for any diagnostics, you have to take a history so you know which criterion to go to. Do you not? You don't know that because you're a lawyer. Okay.
Boom. Hey, this
ouch.
This is not.
You know what? I'm on Team Alex. You shouldn't have interrupted him. He was in the middle of a fine, thought out.
Yeah, I was going to say, if I would take a history, see what the issue is, and then I would open my DSM-5, the Diagnostics
what you were supposed
Manual
to say,
5.
What you were supposed to say is that if I were walking into your office and I was a doctor, I'd say, listen, son, I'm not evaluating from the FAA perspective. I'm evaluating from the clinical perspective. And the clinical perspective...
That's exactly what he was saying.
Yeah,
well,
that's what I was going for.
About taking a history and all this stuff.
That's where you start.
That's what a physician's got to do.
Taking his blood pressure. So anyhow, if you were going into a regular doctor, they're going to evaluate you from the DSM-5 standpoint, not the regulatory perspective. So what's nuanced about the DSM-5, Christopher or Alex, that's not nuanced in the substance dependence, substance abuse definition under the regulation?
Substance dependence and abuse isn't even in the DSM-5 for one.
Say what now?
I say what?
So I think that was a good answer from Alex.
Yeah.
Thank you.
Whereas the regulations, now from the legal perspective, whereas the regulations reference substance dependence and substance abuse as being disqualifying, the DSM-5 doesn't even use that terminology anymore because the substance dependence and substance abuse is antiquated terminology. But yet the regulations and the rulemaking process and how all the sausage is made there behind the doors up in Washington, D.C., they haven't caught on with the rest of the world when it comes to the nomenclature, if you will.
Have you ever seen sausage be made? It's very unappetizing.
Yeah, well, it doesn't look like that stopped you from eating it.
Bad jokes.
Extra
That's
link
why
over
I haven't
here.
lost weight, because it's my persona. All right, so what is the regulation when it comes to substance dependence? Well, I'll tell you this much. It's the same for first, second, and third class. So don't ask that question again. Just don't ask it. If I get a third class, will it be any better? No, it's the same exact thing. First, second, and third. It's a copy and paste from 67.107, 207, and 307.
So are you telling me if I qualify for a third class because I have a history of DUIs, I could also qualify for a first class?
That's exactly
right. What about
right.
second class? The elusive second class.
yeah, you don't see that as much. But same exact thing. It's copy and paste. And what essentially it's after is...
What about basic med?
Basic med, yes.
Okay.
Yes. How about sport pilot? It essentially says no established medical history or clinical diagnosis of any of the following: substance dependence, except where there is established clinical evidence satisfactory to the federal air surgeon of recovery, including sustained total abstinence from the substances for not less than the preceding 2 years, as used in this section, and goes on to identify different types of substances, includes most substances. And then it identifies what is substance dependence. Well, substance dependence means a condition in which a person is dependent on a substance other than tobacco or ordinary caffeine beverages, as evidenced by increased tolerance, manifestation of withdrawal symptoms, impaired control of use, or continued use despite damage to physical health or impairment of social, personal, or occupational functioning. There's a lot to take away from that. Nitpicking it a little bit, and some of the questions we hear a lot is essentially, if I have ever had a diagnosis of substance dependence, does that mean I always have a diagnosis or determination of substance dependence? And yes, substance dependence has a lifetime look back, despite this reference to 2 years within the regulation as far as abstinence is concerned, because it also requires 2 years of recovery satisfactory to the federal air surgeon, which is where a special issuance comes into play, and that's how you can come into recovery satisfactory to the federal air surgeon. But this is not a matter of remaining abstinent for 2 years and poof, you don't have substance dependence anymore. The FAA would require recovery satisfactory to the federal air surgeon. And that also requires that you actually meet the criteria for substance dependence. So sort of going back to the clinical diagnosis piece, essentially, even if you meet criteria for a clinical diagnosis of substance use disorder, it doesn't necessarily mean that you're going to meet criteria for substance dependence, because substance dependence is defined uniquely under the regulations here, as we just identified, as being one of these 4 criteria. And it's not to say you have to meet all 4 criteria for substance dependence. You just have to meet one criteria within your entire history. So now that I've identified that ad nauseum.
Well, I was just thinking.
Oh my gosh. There's smoke coming out of the podcast machine.
Well, what's the difference between the criteria under the DSM-5 and under the regulation? Because the DSM-5, they're going to call it an alcohol use disorder, and then they're going to categorize it by mild, moderate, or severe, right? Whereas, obviously, as you just got done referencing, the regulation calls it substance dependence. So is there an opportunity where you could have a clinical diagnosis of an alcohol use disorder? I'm just using alcohol as a substance du jour. Alcohol use disorder, based on one of the criteria under the DSM-5 or whatever the case may be there, and it not trigger a corresponding substance dependence disqualifying determination under the regulation. Does that make sense?
Absolutely.
But to that end, I was looking at the DSM-5 standards. I actually took the time.
You're taking the time?
I took the time. I pulled it up.
Wow.
I pulled it up and I looked at it. There's 11 criteria here.
Criterium.
Criteria?
Let's have it. Let's have it.
Is that a real thing?
Yeah.
Criterion.
Based on decades of research, DSM-5 points out 11 criteria that can arise from substance misuse. These criteria fall under 4 basic categories: impaired control, physical dependence, social problems, and risky use. It seems fairly consistent with the regulation and the 4 criteria referenced therein, wouldn't you say?
I'd say so.
But here are the 11. You want to hear all 11?
I'd love to hear.
I mean, I don't want to bore everyone to death.
Too late.
Too late.
Bore them to drinking. Using more of a substance than intended, or using it for longer than you're meant to. I think that's impaired control of use.
Sure.
Trying to cut down or stop using the substance, but being unable to. Manifestation of withdrawal symptoms, maybe.
Impaired control of use.
Impaired control of use. Experiencing intensive cravings or urges to use the substance. Withdrawal. Needing more of the substance to get the desired effect, also called tolerance. So I think that's self-explanatory. Developing withdrawal symptoms when not using the substance. Well, there's withdrawal. Spending more time getting and using drugs and recovering from substance use. Neglecting responsibilities at home, work, or school because of substance use. Continuing to use even when it causes relationship problems. Giving up important or desirable social and recreational activities due to substance use. Using substance in risky settings that put you in danger. And lastly, continuing to use despite the substance causing problems to your physical and mental health. So it kind of seems almost as though if you have a DSM-5 diagnosis of a alcohol use disorder, you're pretty much going to end up having to check one of those boxes that would otherwise correspond to the regulation's definition of substance dependence.
Has your FAA medical certificate been denied? Are you concerned you may not be able to get a medical certificate from the FAA? Are you at risk for FAA action for failing to report your medical history appropriately? Call the pilot lawyer at 1-855-FAA-1215 to discuss your options for getting the FAA to issue your medical certificate and get you flying. We are happy to evaluate your case and discuss with you a plan for presenting your case to the AME or the FAA. Aviation law is all we do, nothing else.
Typically so. But then it gets into, well, does it really meet those 4 criteria? Do the facts of your situation really meet that? The FAA is, I'm not speaking for them, but has indicated that the substance dependence threshold is for the FAA is lower than that of the DSM, just because there are less criteria. But again, I think you really have to fit the facts into each of these 4 criteria. Even if you have a clinical diagnosis, how do we, how do the facts get there? So I think it's always a fact-based thing, but the clinical diagnosis is not going to help you.
Yeah, you're not setting yourself up for success if you're already coming into this eventually you can have success.
Oh, you can have success.
Nobody's saying that you can't get a medical because you have a history of substance dependence.
We'll get that in a second.
More work you got to go through.
So going through each criteria here, increased tolerance. What is it? What do we know about it? How does it feel in the palm of your hand?
The way it feels is like a cold Michelob Light on a summer day. I don't know. So increased tolerance, as the FAA has defined it, is typically if you're at a BAC, and we usually see these more in alcohol cases, especially DUIs, where there's been a breath or blood test administered and there's been a resultant value, obtained, where that value is 0.2 or above.
Like an awfully specific number. How did they come up with that? Does
Nobody knows,
knows?
Boss.
Nobody knows. They won't say.
You ask them, and they never tell you. You ask them in discovery, you ask them in trial.
Hey, maybe there's some science behind it. Just tell us.
That's fine. But it seems every time you ask them, it's like, well, that was that's what Father Abraham passed down. That's what Moses came down from the mountain with on the tablet, and that's what we go with.
They clearly are overlooking the science behind it because you just read in the DSM decades of research has gone into this, and they're just going to.
Yeah, but who's
much more?
See, that's the problem.
It's a much more Old Testament version that you just gave there.
Yeah,
Abraham and Moses.
I never really get to the New Testament. Every time I start to reread the Bible, start off in Genesis. You get through it, and then the next thing you know, I never make the new.
Have you heard about Jesus, our Lord and Savior?
Yeah. Who?
Yeah. So all that being said,
that was Jesus.
So anyhow, we've got a situation here where essentially this 0.2, if you're out there driving along, the police pull you over and the police say, hey, do these field sobriety tests, and you're talking to them and you're walking and blah, blah, blah. The FAA identifies that as what they call a purposeful function. They feel at 0.2, you should be comatose. You should be out of it, unable to rouse. But if you're out there walking around, you put your keys in your car, move the car down the road, you're talking and walking and so on, demonstrating this purposeful function, it suggests to them that, hey, somebody with this value shouldn't be at this level of functions. Therefore, your historical use of a substance must therefore be greater than what we'd like to see because you're acting differently than somebody else would. So essentially, it's drinking more or using the substance more and more to reach a desired effect to the extent that you've developed a tolerance. It's fairly on its face, but in practice where we see it the most is once you hit a 0.2, you're almost automatically a substance dependence because of increased tolerance, unless you can make some argument that you don't have a purposeful function. That's where the key is here. If you were unconscious, if you were, if there was this evidence that you were unable to rouse, you're very, very groggy,
You're blackout drunk.
Yeah, there's an argument to say, well, hey, he doesn't have a tolerance, he or she. Now, it gets into another problem later on with impaired control of use, which I guess we can just go ahead and talk about.
Well, you can talk about that, but also briefly want to ask, do you see the increased tolerance criteria being triggered with other substances other than alcohol, or is it typically with alcohol?
Typically with alcohol. It seems
Why is
like.
that?
I just think it's easier for them to quantify. You don't see it as much with marijuana. I guess there are certain circumstances where somebody could say something like, well, I was drinking or I was using so many grams and then I wasn't feeling it and I had to start using so many grams and blah, 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 blah.
There's
don't see that as much.
not to name drop, because I don't know any of these people, but there's this, I think there's like this YouTube video going around where Snoop Dogg was talking about smoking with Willie Nelson and how Willie Nelson's marijuana like put Snoop Dogg down. And he's like, this guy has some serious stuff. No, I mean, I don't know, but it would seem as if,
We're going to have to owe both of them at the end of this.
yeah. But I mean, I guess in a situation like that, well, maybe, if Willie Nelson's able to smoke so much and not affect him the same way that it's affecting Snoop Dogg, then maybe Willie Nelson's built up a tolerance to it, right?
He's got 20 years on him.
Well, look at the two. Willie Nelson, though, my perception is that he's a smaller guy than Snoop D-O-double-G. And therefore, maybe he metabolizes it differently than Snoop Dogg. So that's an argument.
So as an example, there could be a way to maybe show that there is an increased tolerance, but that's going to be again, what are the facts? As you mentioned,
I need to know the facts.
What are the facts? What is this all based on? What are we looking at to establish these, and I'm using air quotes here, facts?
That's good for radio.
Yeah, that helps the listener understand.
Yeah.
But what are the facts that we're relying upon to then fit into the formula that is the criteria for increased tolerance?
I've got you here. I've got you. May I?
Look me in the eyes and tell
I'm
me.
going to look you in the eyes and tell you this. This is another good selling point for why this is a legal process rather than a medical process. Sure, a doctor could try to apply these standards and blah, 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 blah. But at the end of the day, these are regulatory definitions, regulatory requirements with facts fitting into regulatory interpretations from a bureaucracy. And so that's why it's a legal process. I mean, it's what you're putting in front of the FAA, what evidence you're putting in front of the FAA to establish whether or not you meet this criteria is, again, speaks to it being a legal process. That being said.
No, you were mentioning something about purposeful function with respect to increased tolerance, and maybe you just tied one on so hard.
Yeah, I tied a hard one on
and
this scenario.
That you blacked yourself out. Now,
That's
is that
correct.
a concern? So now you're going to say, well, I don't have increased tolerance because I don't have purposeful function.
Well,
I wouldn't be
scenario.
blacked out in my car if I had purposeful function. I'd be driving home, all over the road.
In this scenario, this individual has a problem now potentially for impaired control of use. So what is that? What is impaired control of use? Well, typically the FAA identifies that as binge drinking, drinking to blackout, binge drinking being having drank 5 or more drinks in a sitting.
What is
For
a
a
sitting?
male.
Yeah,
What's a sitting?
You know what? Look at Alex. Give him a wink and a little pat on the back. I'm not going to touch you, but
I did shower this morning.
He must have heard us talking.
You must have heard us talking. So
Yeah.
So here's
Here's
the thing.
something enough.
Here's
on
the,
and on and
here's
on.
the thing.
What
That's
is
a
a
good
sitting?
point. What's a sitting? Here's something we see, though, like back to the instance where the individual had a BAC of 0.2, but they were comatose. So there's an argument to say, well, this person doesn't meet criteria for increased tolerance. In that case, the FAA could say, well, you still have an impaired control of use because you should have stopped yourself until you got to that point. Why didn't you stop yourself? You just drank and drank and drank and drank and drank to the point that you got to a value that you shouldn't have been at that was dangerous to your health and blah, blah, blah. So,
I guess there's, if you really kind of think about it,
okay, let me see.
really think. What's better argument, do you think? You went to the bar with your friends, got there at like, I don't know, say 7 o'clock in the evening, and you didn't leave until 2 in the morning, right? You really had a good time. And you drank during that whole period of time. But then you got to the point where over that period of time, maybe you had 5 drinks or more, BAC got high, but you blacked out, and now, you're in the situation we're talking about. Or you pound the drinks, boom, 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 you do shots, whatever, and you had the 5 drinks, and then you go on about your business, but then it hits you all of a sudden, right? And now you're blacked out. in either one of those scenarios? Is one better than the other?
It's hard to say because you might be able to turn this scenario into where that's, I pounded them, as maybe me and I blacked out. You can maybe make an argument to say, hey, listen, this is a one-off. This isn't a history of drinking to the extent that I've become dependent on it. It was a mistake I made. Maybe I drank more this time than I usually drank and therefore became comatose. But is it impaired control of use? Is my use actually impaired, or is this just a misuse of a substance as would be identified for substance abuse? With substance dependence, though, you might be able to make that argument. You might be able to.
Interesting. All right. Well, moving on.
I would say one other thing.
Oh boy.
Say it.
So
already said
other
it.
times the impaired control of use is like I wake up today, say I'm not drinking today. By 5 o'clock, I've already drank. Or like tomorrow, I'm not going to drink. Tomorrow rolls around and you keep drinking. That's sort of an impaired control of use that we see the clinicians identify as well.
Well,
So there you go.
I said I'm going to stop drinking tomorrow, and then tomorrow comes. So I said, well, I said tomorrow.
Yeah, define tomorrow. Yeah. So manifestation withdrawal symptoms, typically that's a situation where there's some level of, this kind of speaks for itself, some sort of manifestation of ongoing withdrawals, seizures, and so on and so forth. Not every seizure. I think there are arguments to be made about certain seizures and certain rules and regulations here that you might be able to interpret that as abuse in some cases. So I wouldn't say every seizure, but for the most part, the FAA is going to look at a seizure and try to turn that into substance dependence. If it's not every seizure,
symptom?
not every seizure, but if it's in connection with some sort of substance use, the withdrawal symptom.
Oh, so you're saying you tell them about a history of having a seizure, and then they start looking at what was the reason for it. And now not only do you have a neurological concern under 67, 109, 209, 309, now you also got a potential substance dependence concern that you're having a...
They're going to link the two potentially to say, well, what is the correlation of the substance use with proximity of the seizure? And is that something that has required intervention and so on and so forth? So that's something to look at. But again, there's sometimes an argument to say that maybe misuse of a substance could cause a seizure, perhaps, and that maybe would be a better interpretation for substance abuse. So I wouldn't say every seizure you're nailed to substance dependence, but as far as substance-related seizure. So there's that. Manifestation withdrawal symptoms sort of speak on their own. And where we'll see this trigger a lot is if somebody has gone to clinical intervention, they've gone to an IOP, or they've gone to an inpatient treatment program. In that case, there's oftentimes information in those records that suggests a withdrawal symptom. And then that was me snapping. You're there at the withdrawal symptoms. The last prong before Christopher dozes off is continued use despite damage to physical health or impairment to social, personal, occupational functioning.
Purposeful functioning is waning.
Yes. So this is most often is a case where somebody's had more than one DUI or more than one alcohol-related event. It's not if you have like a minor in possession and then have a DUI, that's not always going to be continued use despite adverse effects. It may be 2 DUIs usually going to be this prong.
You know what, though? Is kind of what has typically been told to us. However, we had a trial last year where it was the FAA's expert came in and said that they kind of start to look at that at 3 DUIs.
It's inconsistent.
There is some there's not like an actual policy. Like written, is there?
No, there's not an actual
thing. I mean, you're not gonna see any kind of guidance or policies authored by the FAA where it defines increased tolerance with a 0.2 or 2 DUIs as being continued use. It's just kind of whatever they feel like that fits the narrative at the time to justify their denial.
Well, coming back to our podcast from last week where we were talking about the ARC program, where essentially they're trying to reform mental health diagnoses and concerns at the FAA.
This is a callback.
I think it's a callback. It's first callback ever.
Yep.
If I had a recommendation, or if the Eisen Law Firm had a recommendation,
we had recommendations last.
Well, we're going to have more recommendations. So
Here it comes. Buckle up.
Scrop just went on a little scrap of paper. I can't say it.
Put it on a little scrap of paper. A little scrap of paper.
Put it on a scrap of paper.
We're going to owe Shaun of the Dead now, too.
Put it on a scrap of paper. So scroll this down here.
Scrappity scrap.
Here's my thought is that if you were to reconstruct how these things, how someone's history meets this criteria for substance dependence, if that would be something that would, one, save a lot of time at the FAA, because right now they've got it set up to where if you had a DUI 20 years ago and you happen to meet one of these criteria, you have substance dependence, you have to go through the process.
And we buried the lead on that on this one.
Right.
We didn't even mention that it's a lifetime look back.
It's a lifetime look back. So that's the thing. If you essentially have any indication in your history, your lifetime history from when you're 12 years old or whatever, if it meets one of these 4 criteria, it's always going to be substance dependence. And then the question then becomes for the FAA, well, if you meet it, are you in recovery satisfactory to the federal air surgeon? So I think if they were to retool this to where not everybody was meeting criteria for substance dependence and it was a bit more realistic, that would save the FAA time, save workflow problems and so on and so forth, and be less arduous of a process for individuals that maybe had a DUI 30 plus years ago.
Are you advocating for government efficiency?
Not really, but sure. So if you get pinged with substance dependence and you can't beat it, if you will, if you can't beat it, if you can't establish...
Join it.
Essentially. So if you can't establish that you don't meet criteria for substance dependence or a lesser of substance abuse, if you meet criteria for substance dependence, you can still get a medical certificate if you establish recovery satisfactory to the federal air surgeon. Now, what is that?
We took the words right out of my mouth.
Well, let me suck them right back in by telling you this. To be in recovery satisfactory to this federal air surgeon, you have to do the following. You have to either attend a 28-day inpatient treatment program or an intensive outpatient treatment program. What are you doing that face for? Intensive outpatient treatment program. And then followed by that, engage in ongoing group aftercare with a counselor or therapist. And also engage with what's known as a HIMSS-trained AME and do ongoing random urinalysis to prove abstinence from the substance of dependence. Also engage in 90 peer-to-peer group recovery program like AA or Narcotics Anonymous, 90 meetings in 90 days, and then have ongoing engagement with such a program. After such data is developed and to the HIMSS AME satisfaction, you'll then have a HIMSS psychiatric evaluation and a HIMSS neuropsychological evaluation, upon which all of that data and those reports will be compiled and sent to the FAA, upon which the FAA will review that evidence to see if you are in recovery satisfactory to the federal air surgeon, which unfortunately in and of itself can be a several month process, 9 months plus in some cases. So in this instance, if you know going into the process that there may be a concern with substances, you either A, want to get on the ball of trying to argue that you don't meet criteria for dependence if applicable, or before the FAA starts telling you to do these things, start getting involved in the treatment program and so on and so forth to establish your eligibility for the special issuance that the FAA is inclined to ask for, because the sooner you're proactive, the sooner you'll have your medical certificate in most cases. That being said, also, I would also encourage individuals that if they did have a DUI 20 years ago or something along those lines, where there's an argument that ongoing treatment or initiation of treatment, I should say, is not appropriate from a clinical perspective, you may be able to make the argument by having a proactive evaluation from a HIMSS-trained psychiatrist to assess whether or not recovery activities are really appropriate and to what extent they are appropriate based on your level of recovery and so on and so forth. So if you have gone through some sort of recovery program previously and so on, it may not be appropriate to start all over from scratch. And sometimes, again, that's where an aviation attorney can come in and try and help mitigate those concerns through the process. Now, if for whatever reason the FAA says you have substance dependence and you vehemently disagree with that, you could potentially litigate that at the National Transportation Safety Board, whereupon you could petition the NTSB and litigate the question before an administrative law judge and identify whether or not you really have substance abuse or dependence, whereupon you'll have to provide evidence from experts to establish that you don't meet one of these 4 criteria, that your history does not meet one of these 4 criteria that we've discussed.
I think that's sometimes misunderstood though by people. They think, well, I'll just go to the NTSB and they'll see it differently. And that's
Wrongo.
That's not quite how it works in a lot of instances. What the NTSB is looking at, they're looking at the airman medical file that the FAA had at the time of denial. And they're looking to see whether or not the FAA erroneously denied your application based on the alleged condition. You have the burden of proof. So you have to go in there and prove by a preponderance of the evidence, which is typically said to be 50% plus a feather, to tilt the scales in your favor, that the FAA made an erroneous decision. If throughout the process of trying to get your medical, you're submitting documentation to the FAA where you have clinical evaluations or evaluations from psychiatrists or neuropsychologists that are HIMSS trained saying that you meet the criteria for substance dependence, you're going to have a kind of a difficult time going in there to the NTSB and saying, well, I don't have this, because then all the evidence that the FAA would have had at the time of denial would have supported the denial. Right, Anthony?
That's absolutely right.
So,
I could have said better if I hadn't trained you myself.
Well, I don't know. So it's important then, I think, is what the takeaway from this should be, is if you do eventually want to go to the NTSB, you need to start thinking about that before you send anything to the FAA. So that way your argument, I don't want to say narrative, but your argument, your defenses.
Yet you did.
But I did. Remains consistent. I mean, that's one of the big things in law, and that's a big way that attorneys can kind of nitpick and create inroads into their arguments, inconsistencies from one witness to the next or within the witness's own statements, and inconsistencies within the argument. So if you start off and you acknowledge, hey, yeah, maybe I do have substance dependence, but then eventually down the road you decide, I don't have it. I want the NTSB to look at it. And you say, well, this is why I don't have it. Well, now there's an inconsistency in what you've kind of put forth previously, and that's your credibility is going to be shot.
Well, can I make a confession myself?
Oh, gosh. Do I look like
You
a
zoned
priest?
out.
I am heavily dependent upon.
We know you're heavy.
I'm heavily dependent on food, and I am getting hungry, gentlemen. Subway awaits. We are recording at lunchtime. All right. So, Alex, you've been sitting here listening, I think, doing nothing.
Kinda.
Got any takeaways here?
I think once you get
Where's the cricket sound
to
effect?
the substance dependence realm, you need an attorney, because what you're putting into the file is going to really make you or break you as far as getting your certification.
That's beautiful.
All right. Well, you've logged another uneventful half hour listening to the Pilot Lawyer Podcast. And even though the people at Subway will vehemently acknowledge knowing Anthony, we are the
Usually,
Ison
as
brothers.
I'm walking to the door, they're running to the door to lock it. I'll get a foot.
We're
long.
out of food.
Sold out.
I'll get a foot long with double meat.
All right. Well, we're the Ison brothers at the Ison Law Firm. Have a good one.
Okay, see ya.
This is thepodcastfactory.com.